Welcome everyone again to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science, featuring experts in behavioral health and the law. This is a series run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, make sure you enter them in the Q&A box. You can put those in the Q&A box anytime you feel comfortable. Just know that we hold those questions until the end. We try to get to as many as possible, but forgive us if we don't get to yours. If you are pursuing continuing medical education credits, there will be a sign-in sheet posted in the chat box shortly. The sign-in for APA continuing education credits will also be in the chat box, but in the later portions of the talk. Make sure you check the chat box for later on. If the link's not working for you, bookmark it for later. Save your certificate after you complete the survey too, because we don't have access to those after the fact. If you missed last week's talk in the series, Dr. Cassie Bailey's discussion of linguistic and cultural considerations when doing forensic evaluations with Latinx and immigrants is now available on our YouTube channel. The PowerPoint slides for this talk should be available for those that have registered for the series later this week. As a heads up for next week's talk, we have Dr. Andrew Perkins, who will be discussing evaluations of youth with problematic online sexual behavior. But circling back to this week, I'm very excited to introduce you to today's speaker who will be discussing race and legal issues in workplace discrimination evaluations. This is Dr. Jemour Maddux. Dr. Jemour Maddux is a fellow of the American Academy of Forensic Psychology and a board-certified forensic psychologist. He serves as core faculty in the Doctor of Psychology program at William Paterson University in New Jersey and as examination faculty of the American Board of Forensic Psychology. He's a former chair of the American Psychological Association's Committee on Professional Practice and Standards and co-edits the Best Practices in Forensic Mental Health Assessment book series published by Oxford University Press. He's also done important work in the American Psychology Law Society's Bridge Committee, the Broadening Representation, Inclusion, Diversity, and Global Equity, including being part of the working group to bring that name up to date from the Minority Affairs Committee. So Dr. Maddux, Jemour, on behalf of the University of New Mexico, we're very excited to have you joining the series and thankful that you're going to be sharing your expertise with us today. I will go ahead and throw it over to you.
Thank you so much. And I am delighted to be with you all today. Some housekeeping items concerning CE. I think you've already gone over that to some extent, but you can make note of what's on the screen here. And I have no financial issues to disclose that could affect the objectivity of my presentation today. And of course, the views that I will be expressing are just my own. They don't reflect the University of New Mexico, William Paterson University, the American Board of Forensic Psychology, or the American Academy of Forensic Psychology. I'd like to share a story with you. In 1865, the 13th Amendment abolished slavery, and in 1896, despite the 14th Amendment, a case called Plessy v. Ferguson led the Supreme Court of the United States to conclude that separate treatment was not unequal or inferior treatment, and that established the separate but equal doctrine, which was the law of the land for many years in the US. In 1935, a man named Percy Green II was born. He was raised in St. Louis, and he'll be the main character of this story. We're going to loop back around to him in a bit. But first, just continuing on with this timeline here, there was rampant discrimination in the American workplace. And the first pushback to rectify some of these issues was within the federal sector. President Roosevelt, under pressure from civil rights advocates, issued Executive Order 8802 in 1941, and that barred discrimination based on race, creed, color, and national origin within the defense industries and federal employment. The problem is that the thing had no teeth and support for it diminished, that is, financial support. Harry Truman, who was next up to the plate, did his best a few years later and continued on by issuing executive orders of his own to desegregate the armed forces and to stop discrimination in federal jobs and in federal contracting. But all of this good work just covered the federal government. Private sector was still able to do whatever they pleased, and discrimination continued to be rampant. New York actually led the way with respect to addressing these issues in the private sector in 1945 by enacting fair employment laws aimed at preventing discrimination in private enterprise. Similar to the work of FDR, their bill also lacked teeth, meaning a significant enforcement mechanism. Then SCOTUS does a 180 with Brown versus the Board of Education in 1954, ruling that separate but equal was no longer constitutional under the 14th. Just a couple years after that, our main character in 1956, Mr. Green, got a job working as a mechanic for a company called McConnell Douglas. It was an aerospace manufacturer in St. Louis, and about 7 years after that, in 1963, President Kennedy addresses the nation and says, listen, I'm planning on introducing this bill. It's going to be a major civil rights bill that's going to address, amongst other things, the discrimination happening in the American workplace. Unfortunately, before all was said and done, he was assassinated. And next up to the plate, we have Johnson, who picks up this work, signs the Civil Rights Act of 1964, which contains a section known as Title VII. Title VII prohibits discrimination in the workplace based on race, creed, color, religion, sex, and national origin. Maybe just days, I don't even think it was a week, maybe just days after the signing of the Civil Rights Act of 1964, our friend Mr. Green and his buddy Rich, they decide to climb that big arch thing in St. Louis to protest workplace discrimination.
What are they trying to prove? What is it that they are seeking in this particular type of demonstration?
Well, this is their method of calling attention to the fact that they want jobs. They feel that this hit and miss proposition is no good. That's the words that Mr. Green used. And that they want a lot of jobs. They feel they're entitled to a lot of jobs, and they want them now.
We are not just demanding one job for one Negro. We are demanding that the whole pattern of discrimination in the construction industry be changed in order to include Negroes in all skilled jobs.
Mr. Green, who was employed at the time he engaged in this protest at McConnell Douglas, said that this hit and miss proposition is just not going to work for us anymore. About 2 months after this protest, guess who was laid off? Mr. Green from McConnell Douglas, for what they said was just general workplace reduction. We're just reducing staff. But shortly after him being laid off, guess who's hiring specifically for mechanics? Well, it's Mr. Green's old job, to which Mr. Green applies, but unfortunately his application is rejected. The former employer says it's because you are a part of protests, specifically an unlawful protest. But Mr. Green disagrees. He said this is because of racism, and he brings a case which went on to become a landmark case and establish the pathway that's still used today in many states for proving employment discrimination in the US based on indirect evidence of racial discrimination. And what you see here in the picture, it's an actual portrait that's hanging in some type of museum, either in or around the grounds of that archway that Mr. Green climbed with his buddy, I think, Rich, several years ago. Today's presentation isn't about how to do these types of evaluations. And I know some of you are bummed out. Maybe you're expecting that's what this would be. This isn't a how-to presentation for employment discrimination / harassment evaluations. Rather, this is a presentation that, as the title says, will cover race in the legal system as relevant to your workplace discrimination evaluations. We're going to be focusing on the legal system, jurisprudence, law, policy, as it intersects with race in a way that could help support the work you're already doing in this specialty. If you're not currently doing this work and you're hoping to break into it, and you were thinking that this presentation today could assist you, I would suggest that you pick up, that Delahunty and Foote text in the Oxford Best Practices series. It's a solid text. Certainly do an updated literature review about what the authors and other authors have had to say about this population since the publication of that text. Go out and get some supervision, go do some consultation, and then you'll be well on your way to doing some of this work. And when you get that racial discrimination case, then certainly dig up these slides to support your foundational knowledge. And this pathway to doing this type of workplace law evaluation is sound, assuming you already have solid forensic skills and you're already in the specialty. All right, so at the end of today's conversation, you will be able to list legal principles underlying the referral questions that we often see in this type of work. You will be able to contour your evaluation and your opinions based on the limitations of what we know in psychological science concerning this population, racism, and its impact. And you will be able to, if you're doing like a work product review, or if you're helping out a peer, or even reviewing your own work, you'll be able to look at that conclusion section and say, you know what, that's not quite right to say based on that presentation Maddux did in 2024, and these are the reasons why. So those are the goals for today's presentation. Legally speaking, I think we have to start off with the Civil Rights Act of 1964, and here's the key language from Title VII. Let's read it. And it continues here on the next slide. To limit, segregate, or classify. So that's the operative language that prevents racial discrimination in the workforce, dating back to the Civil Rights Act of 1964. And I think that's just facially clear. Let's talk about the junctures at which discrimination can happen in employment. It's within these different aspects of employment, whether or not I'm going to hire this person, terminate this person, give this person PTO, give this person a perk, an assignment, a promotion, a transfer, if this person will be laid off. It's at these junctures that discrimination can occur. So what's discrimination? Discrimination is what you see on the screen here. It's I'm going to treat this person differently, or I'm going to collect information which shows an intention to treat people differently who are from protected classes noted in the Civil Rights Act of 1964. And notice harassment or harassing behavior is part of discrimination. So what's harassment? Can include many things, ranging from the more subtle stuff, like a hostile demeanor, though courts generally don't look very favorably upon awards based solely on that, unfortunately, according to research published by Stern. And it could also range all the way up to hanging nooses on doorknobs and bigoted language, even physical violence. That's all forms of harassment. Now, you've heard of the EEOC. Congress created the EEOC in order to process the claims they were expecting to come in from the ratification of this Act, and specifically under Title VII of the Act. And today, if you've been harassed or discriminated against, you have to file with the EEOC within 180 to 300 days, depending on some different technical issues. And after the EEOC does its good work, you will receive a letter, most likely, it's almost always given, saying you have the right to sue. At that point, you can bring a case against the employer, but it has to be within 90 days of receiving that letter. Now, irrespective of how that case goes, let's say you settle, and most of the times these cases do settle. Employers have a lot on the line by letting these cases go to a jury trial. They have a lot to lose, financially speaking, particularly if punitive damages are involved. And if plaintiffs sustain all types of motions to dismiss, all types of summary judgment hearings, and has already, rejected prior offers to make a deal and is, just insisting to go to trial, the person probably has a good case if it's made it that far down the pipe. So employers are really, really eager to avoid taking these cases to trial. But that's something that you could obviously do once you receive that right to sue letter. And if you do indeed settle, as they are motivated to do at some point down the line, EEOC could still be so outraged by what that employer has been alleged to do that they could still continue litigation against that employer, even though your efforts to pursue litigation personally are done. Technically possible for the EEOC to do that, but extraordinarily rare. Let's discuss the litigation of discrimination cases for disparate treatment. You've heard of disparate impact. Right now, we're focused on disparate treatment. They all start with a victim having to take action, whether it's direct evidence of disparate treatment or indirect evidence of disparate treatment, or if it's disparate impact, it doesn't matter. The person, the plaintiff, the alleged victim has to start the action. People debate that and say that that's not right in the scholarship, but that's the way that it is for now. Now, when there's direct evidence of discrimination, which is rare because employers are pretty good at covering their tracks, according to scholars, the plaintiff must demonstrate that the comments are capable of only one interpretation and that they reflect a discriminatory attitude correlating with the discrimination complained about by the plaintiff. Plaintiff will also have to show that these comments were made by a person that was a decision maker. We already spoke about the different decisions that someone can make: PTO, raises, promotions, etc. So someone who had the capability of doing one of those things is the person who made this comment that can only be understood one way. Okay. Now, again, these cases are rare, meaning cases of disparate treatment where there is direct evidence of the thing. What's more common, though, is cases like Mr. Green, where there's this indirect evidence, tries to get on the job. They're hiring for a position he was just laid off from because of a general reduction in the workforce. And there's this, what is sometimes referred to as a pretext explanation he's given for why he is not being hired for that position. So there isn't a noose hanging on his doorknob. No one has scratched KKK into a wall in his office, or he didn't get his hands on an email exchange from a decision maker that demonstrates some racial animus. It's all indirect, and these cases are much more common. And Mr. Green's case against MDC established the cause of action for how the framework continues to flow today. It goes something like this. It's interesting the way that it works. First, someone like Mr. Green would have to make a prima facie showing that here's the discrimination that occurred. After successfully doing that, the burden of production shifts to the employer to say that, no, here's the real reason why we made this decision and how discrimination was not involved. Assuming employer is able to do that, the burden of production then goes back to the plaintiff to show, that was just a pretext we just heard from the defense. And the decision was actually motivated by discrimination. Now, if all goes well for plaintiffs like Mr. Green at that particular juncture and they're successful in doing that, then it would compel a finding of discrimination. Since the 90s, however, it no longer generally compels a finding of discrimination if someone gets that far. Rather, it may result in a finding of discrimination, a finding that's ultimately up to the fact finder. I should also note that while we have this shifting burden of production, the burden of persuasion doesn't shift. It's always set at preponderance, and it's always for the plaintiff to reach that burden of persuasion despite this shifting burden of production. So for those who have done mostly personal injury work, tort work, this shifting burden thing may be new to you. So there it is. Okay, these are examples of disparate treatment cases based on direct or indirect evidence. Let's talk about disparate impact. And here we have the Griggs v. Duke Power landmark case. The cause of action is quite different for these. First, you need to show that there's this significant disparity between the proportion of protected group members available for a job and the proportion hired for that job. And secondly, the employer has to have in place some apparently neutral, facially neutral employment practice, like some type of IQ screener, let's say, that plaintiff is alleging to be causing that disparity. And lastly, plaintiff must demonstrate that indeed there's this causal nexus between that practice, like this IQ screener, and the disparity that's showing up. And once the plaintiff establishes these three elements, the employer, kind of like we see in the indirect pathway that Green used with MDC, the employer can then attempt to justify the practice, say, no, that actually serves a legitimate non-discriminatory business objective for us. And if the employee succeeds in showing that that's some type of pretext, then they will be successful in their case. All right. So we've covered disparate treatment, and based on indirect and direct evidence, we've covered disparate impact. Now we're going to discuss hostile workplace under Title VII. Many of you have probably heard of hostile workplace, hostile work environment litigation. And that brings us to the landmark case involving Meritor Savings Bank v. Vinson in 1986. It's actually a sexual harassment case. It's not a racial discrimination case, but it established this hostile workplace means of recovering. And here's how it goes. The plaintiff, Michelle Vincent, she was discharged from her job, subsequently says the VP of the bank was sexually harassing her for over 4 years regularly. And she said this created a hostile work environment and claimed that that was covered under Title VII. Up to that point, I don't believe people were bringing such claims under Title VII. She sought compensatory damages, that's new now, and punitive damages, which is new. So now we're seeing people going for damages that aren't just based on money, like getting a job to earn money or not being promoted fairly to earn money. Now it's based on like, this harmed me psychologically. And she's seeking recovery and relief for the economic piece, but also for this emotional piece. And so it raised the question for SCOTUS whether or not the Civil Rights Act, 1964, whether or not those Title VII protections extended to such damages, or whether or not it was just about economic loss. Long story short, Michelle won her case, though the court stopped short of talking about the degree of liability for which the bank should hold. Now, with the Daniels v. Essex case, we see an analogous case, but it's for racial discrimination. Poor Daniels over in Indiana suffered horrific, when you read this case, horrific racism at his place of employment, and took it on the chin for quite a bit. The court found that indeed this poor gentleman suffered this horrific discrimination, and the claims of a hostile work environment were established and indeed were found to fall within the scope of Title VII. So let's talk about the cause of action for this hostile workplace means of recovery. Here's how it goes. It has to be sufficiently serious and frequent, the racism, let's say, to produce a hostile work environment. It has to be severe and or pervasive. One-time comment that's subtle, one eye roll from someone not the same race in a decision-making capacity, although that might trigger you in a horrific way, that's usually not going to get it done. And then we have this two-part test. It has to be objectively hostile, what the person experienced, and subjectively hostile. Subjectively hostile, that's the easy one. That's the person's reports, for which psychologists can be instrumental in assessing and explaining for the court. The objectively hostile one, we could also be helpful for that, but this is the more controversial test for whether or not the environment was indeed a hostile environment, because it relies upon this reasonable person standard. And it's like, what in the world is a reasonable person when it comes to how a particular racial slur makes me feel? Is it a reasonable Caucasian person, a reasonable African-American person, if it's a case where someone has used the N-word in a decision-making capacity? And how many times does a reasonable Black man have to be called the N-word for it to be pervasive enough and severe enough? Halcombe says, I think one is enough, Halcombe 2016. It makes a good argument why, given how psychologically injurious such language can be based on the historical experiences of Blacks in the US and the use of that word. So this is something that's debated by academics a lot. What reasonable person, what do we mean by that? Because scientists are left scratching our heads about how that's pulled off by the courts, but the courts don't scratch their heads as much concerning that particular issue. And it really isn't raised during the litigation of these cases as being some type of stumbling block, but it certainly is in our literature. Interestingly enough, when you look at research concerning judicial decision-making, there are data suggesting that when a judge, particularly an African-American judge, is racialized to be the same as the racial identification or racialization of the plaintiff, then those judges tend to rule more often pro-plaintiff. So that's fascinating when you think about whether or not the court is colorblind as to this reasonable person standard. At least that one paper I have in mind suggests that maybe not so much. But I think research like that should be looked at with caution. So we've covered hostile workplace, disparate treatment, disparate impact, the various causes of action for these particular pathways to relief and recovery. Now, continuing on here with with hostile work environment, it raises the question, especially as an evaluator, well, how much damage must be shown, psychologically speaking, not damages in terms of relief, but psychological harm, damage must be shown for recovery to be granted. And the thing is, according to Harris v. Forklift Systems, the answer is not that much. The plaintiffs don't have to be psychologically a wreck or damage, or even to the point where they're experiencing functional impairment on the job, to get a ruling in their favor. And so whether or not experts were needed in these cases, when these decisions were coming out concerning the Vincent case and the Daniels case, experts generally were not thought to be needed in this work. And even now, when I get a call from plaintiff's counsel or defense counsel in an employment discrimination case, usually I hear something like, I usually don't use experts for this. I really don't know how it goes when using an expert, because they generally have fared well without bringing folks like us into the mix. And again, that cuts both ways. Defense and plaintiff's counsel, I generally hear something like that. Now, I'm sure Delahunty and Foote's phones ring more often for this type of work, and I'm sure they get more repeat customers, since their scholarship is really lays out the prevailing model for going about this work in this subspecialty. Though I find this case to be interesting, and I find what I've heard from my experiences from counsel to be interesting, I'm generally hearing experts are routinely brought into hostile workplace cases. And certainly the goal by the employer is to get this thing dismissed on summary judgment. There's research suggesting they're often successful with that, and that's how the court spends most of its time with these matters. It's debating whether or not it should be dismissed. By the time this thing is going to trial, this case is a rare bird. And so that's just going to narrow the opportunities right there for experts to be recruited to get into the mix. All right, so we've covered the cause of action for 4 different issues: direct treatment, there's 2 pathways, direct impact, hostile work environment. We also have to discuss retaliation. Under Title VII, engaging in activities consistent with the spirit of Title VII puts you into a group that makes you a part of a protected class. So if, for instance, a coworker is pursuing a case of disparate treatment, you testify on the behalf of plaintiff in said case. You are now a part of this protected group. Okay. If an investigator from EEOC is coming around, knocking doors, and they ask for your 2 cents, hey, you know, Bob, how have your experiences been with Bob, who is the decision maker that's alleged to have done a thing that shouldn't have been done? Now, you taking questions and answering them makes you a part of this protected group. All right. And if you give the EEOC a call one day, boom, right there, you're a part of the protected group because you're reporting alleged discrimination that you believe to be happening on the job. Now, if you're able to establish that you've engaged in this protected activity, putting you in this protected group, and you're doing fine on the job, at least in terms of the employer's legitimate expectations of you, as opposed to overly lofty expectations that may be used as a pretext later on down the road here. But if you're able to show you were doing fine in terms of employers' legitimate expectations, and you're able to show that after that, your report, your protected activity after that, there was then some subsequent, bad thing that happened. You were denied PTO, you weren't given that promotion, perhaps you were terminated or something like that. And you're able to show that there was this causal nexus between the two, then you can be granted recovery for retaliation taken by the employer. All right, cool. So everything I've covered so far has been about the Civil Rights Act of 1964, specifically Title VII, But now I want to talk about the Civil Rights Act of 1991. How many people knew that there was a Civil Rights Act of 1991? But it was a repolishing and updating of the 64 Act. And there were some major additions. So now people could seek damages for potential employment discrimination based on protected group status, except for certain issues. Before, it wasn't written in the act that you can seek certain types of damages, but the Act of 1991 made that clear. However, it did establish a cap for these damages. And by the way, this EEOC thing and whether or not any of this is applicable, it's only in businesses with 15 or more employees. For businesses under 15 employees, there are other pathways one might be able to take in order to seek relief. But what I've covered so far concerning the Act and EEOC, you have to have 15 or more employees. That comes to mind because the cap that's been established on damages under this 1991 rendition of the Civil Rights Act, that cap fluctuates depending on how many employees are at the business. Bigger companies, bigger cap. All right. Other issues that created by the 1991 Act. So now, with the passage of it, you can demand a jury. And there's this motivating factor, mixed motives pathway to recovery. So there wasn't this necessity to show that but for me being this type of person, religiously or racially, this horrible thing wouldn't have occurred. Instead of having to show that type of but for causation to get recovery, you can also show that, no, it was other things too. It was a mix of things that led to this, and you can still be granted relief, not damages, but relief. So the 1991 Act cleared up some of the confusion that was bubbling concerning what level of causation needed to be shown in these cases. There was also some confusion bubbling in the courts concerning the level of the burden of persuasion, with clear and convincing getting into the mix at times. But this act clarified that, and it continues to be preponderance. Good news is that expert fees were now able to be covered because of the language of the act. Before that, I mean, legal fees could be covered, but the act in 1991 clarified that expert witness fees could be covered as well. So this shows some of the issues concerning the causation piece of things with 1964 and 1991. But then there's this more recent case of Bostock v. Clayton County, Georgia, in which Neil Gorsuch really provides a lot of information all about causation and what ought to be shown for liability to be granted in these cases. And I think that is something worth knowing and checking out if you're doing this work to learn more about, because a lot of your conclusion section and the language that you choose when making your final conclusion to answer the forensic question is going to revolve around if it's but for causation or whether or not it's mixed motive. And this is all something that you can obviously research for yourself by looking at these cases. But I think you could also look at the complaint to see how it's worded in the complaint that you receive in your background information. Just so that when you do the best thing, which is to ask your client, the lawyer who's retained you, which one it should be, you will sound at least a little bit knowledgeable on the issue. So the next piece here that I'm going to get into concerns remedies and what could be granted in these cases. You get your back pay, get your job back. Punitive damages, meaning those damages above those required to get you back to right again. Punitive damages referring to those damages that are really about sending a message to other employers like, hey, don't engage in this nonsense. Out-of-pocket expenses, of course, and litigation fees, changes on the job to fix the issue could be granted, like injunctions. And here are the specific numbers concerning the cap. Now, believe it or not, although we're talking about the act here, not all of these cases are going to be held in the federal courts. Many times lawyers are motivated to get these cases to held by friendlier juries or in venues that are known to be more plaintiff friendly. And so they enjoy that Yellow Freight System v. Donnelly indicated that the federal courts aren't the exclusive jurisdiction for these matters. What that means is that you might be operating under Daubert, you might not. You might be expected to produce a report based on certain rules that require your history of testimony to be indicated, and as well as some other issues. Or it may just be the reports you perhaps are more accustomed to producing that are used in your local jurisdiction in the state system. So what you see here is a set of referral questions. I've been asked to provide my views and opinions on whether or not this person's psychological response is connected to this litigation and the likelihood of developing such a response following such an incident. And perhaps now you're more aware of why the common referral questions we receive, as indicated on screen, are written this way. Why is question 2 there? Well, it's there because of that reasonable person standard element. In question 1, well, yeah, it's obviously because a lot of the case turns on that, but there's also that subjective standard piece that's attached to it. And someone can also be bringing a claim for, let's say, retaliation after the racial discrimination they reported, for which they are also bringing a claim. And so that might be captured in one of the questions that you're being asked to answer here. And hopefully that settles you up with learning objective number 1, the legal issues that underlie some of the common referral questions you receive in these cases. Now, the literature concerning racial discrimination in the workplace and how it affects people is pretty well developed. We have a good idea of how it affects individuals from racialized groups. There's this good chapter by Root, 2005. Root starts off by describing Mr. Castellano, who experiences spike in his diabetes, his blood pressure, his cholesterol, asthma, arthritis, all of that starts to intensify due to racism experienced on the job. Root goes on to describe how workers from racialized groups experiencing discrimination on the job can become self-conscious and be plagued by self-doubt and worry and nightmares and sleep difficulties and hopelessness, as well as anger. And all of this can start to obviously impair how they are performing on the job. And then there's this work done by Chu and Kelly in 2006 that provides kind of a description of what a plaintiff may look like, demographically speaking, according to a series of recent cases. And then we have some interesting research by Krieger, who found that certain issues such as smoking and some other issues weren't tied to racial discrimination in a way that the author expected. So not what you would anticipate based on the bulk of the literature out there. Krieger et al. Goes on to say that this group has studied a similar cohort and has found data that is contrary to the findings of that particular 2008 study. So if confronted with this 2008 paper, you could scan down a bit towards the end and see that there's a 2005 paper cited by the same team that brings that particular finding into doubt. Goodman, Delahunty, and Foote, 2010 best practice series. They have a very useful table in their text, which goes on to describe psychological outcomes, physiological outcomes, and work-related outcomes associated with workplace discrimination and hostile work environments. Under the psychological outcomes, they describe anxiety, depression, distress, PTSD, fear, hostility, loss of control, poor overall well-being, life satisfaction decrease, and stress. And under each of those particular areas, they cite a few papers that have shown that. For the physiological and somatic outcomes, they describe binge eating, blood pressure change, crying spells, gastrointestinal issues, hypertension, headaches, alcohol consumption, and again, providing relevant studies that you can just check out to support perhaps your argument about what a reasonable response might be, or perhaps just getting some understanding of the base rates to inform your work and to check bias. Now, in terms of work-related outcomes, the research indicates, according to that table, decreased productivity, lower job satisfaction, attrition, decreased commitment to the job and to different work groups, and a variety of others, again, with the researchers that have found these things to be at issue cited for your easy reference. Okay, so racial trauma and instruments specifically to assess it have been developed by Liu et al., Carter et al., and Williams et al., 2018. In addition to others, Liu's instrument designed to assess for racial trauma, specifically for an Asian, I believe, veteran population. Williams' instrument, somewhat unique in that it provides a pathway, kind of structured, if you will, that can lead someone to a diagnosis, lead the user of the instrument to a diagnosis of PTSD if supported by the data collected. In terms of the empirical limitations of the psychological science here, a lot of it is correlational research. A lot of it is cross-sectional, meaning based on these studies, you can't draw a causal connection between this person has experienced these types of things on the job, as indicated by the formation of this cohort, and here's the diabetes, the hypertension, and the stress. Therefore, we know one is causing the other. I mean, those studies just aren't conducive to that. There have been meta-analyses done, I think, which are helpful. The Triana et al. Paper is an example of such a meta-analysis. The findings go in the expected direction, which is that racial harassment, discrimination don't serve us well, and in fact are harmful. And so, yeah, and there are a few longitudinal studies which also make the point, though not as many as the correlational studies that abound. So those are the limitations of the science when it comes to this type of work. The instruments that have been developed that you might want to reach for and use in this work when you have a racialized examinee before you, like the Liu instrument or Carter's instrument, you know, those instruments look interesting to me. I'm curious about them. Probably I would have to do some research to really see if it would pass muster with Daubert. I haven't heard anything strongly supporting that they would or wouldn't. It's just kind of a big question mark that needs to be addressed prior to using one of those instruments. So I would proceed with caution concerning racism as a qualifying event, as captured by these instruments in a construct, and as the instrument's been put together, and how that would all work with Daubert, given the research on these instruments. Interesting paper here by Chu and Kelly, looking at a bunch of cases that have been decided concerning the prevalence of the problem. And, you know, I found this to be really interesting. African Americans make up about 12% of the labor force, but they make up 81% of plaintiffs in the cases sampled by the authors. Coming in second place, you have Caucasians making up almost 9% of litigants in these cases, though they make up 70% of the workforce. It just goes to show how striking the level of disproportionality is concerning African Americans as plaintiffs. So we have that interesting finding. Now, in terms of the qualities of perpetrators, generally the perpetrators identified in these cases have been white males. And in terms of who usually wins, it's usually the house, so to speak. Employers are successful in defending against these cases at a rate of 80 to 20. So in 20% of the cases sampled, plaintiffs were successful. Some things helped boost those odds to a statistically significant degree, and that would be if the plaintiff was Hispanic, for example. Interestingly enough, litigation, at least in the cases sampled, brought by Hispanics, suggests that they are underrepresented as litigants in these cases, meaning they make, given the size that they make in the workforce and how low they are in terms of the number of cases being brought in these matters, there might be an underrepresentation there. So I'm not sure if that's used in the argument by plaintiffs' counsel in these matters, but perhaps that contributes to issues of credibility and how being Hispanic leads to generally a more successful outcome than being a part of another group. Again, a statistically significant increase if the plaintiff is Hispanic. Also, when there's this pairing of, you know, the case isn't just about racial harassment, it's also about retaliation. It's also about, it's not just a hostile work environment or retaliation, it's also disparate treatment. That pairing also helps to increase the odds of a case being successful. So if you look at this opinion section here, in my opinion, such and such experienced harassment, and she would not have developed PTSD. If you're doing a work product review, I would hope that you would catch, like, you know, that issue of touching liability and saying, yeah, in my expert opinion, this person has experienced harassment outside of my scope. But the second conclusion here, which is that these opinions are based on the findings of psychological testing, clinical interviewing, etc., showing that nice multi-trait approach, that's perfectly fine. And that looks good to me. We like to see that in the opinion section. Now, when you see here the first opinion in the first statement in this opinion section, the most likely explanation for her severe persistent functional impairment are the actions by, you know, I like that there. I like the most likely language to capture it. And I like the inclusion of some key language that's relevant in these matters. But for the next one here, in my opinion, based on the results of this instrument, and this is the instrument developed by Lou, we have this diagnosis of PTSD for this African-American patient. Well, the instrument developed by Lou, remember that wasn't developed for African-Americans. And it would be the Williams instrument that actually is helpful in rendering a PTSD diagnosis, according to what Williams has said in the past. Some references for your review, and let me know how I can help if there's anything I can clarify, any questions or concerns.
Thank you so much, Dr. Maddux, Jemour, for going through all of that with us. You know, the historical piece, telling us where we got here, as well as just laying down what the groundwork is and all the complications that can come about that, and then ending on some practical snippets for those that might want some more of the practical elements that they research further, is much appreciated for the audience, I'm sure.
You're very welcome. Thanks for that recap. I'm glad you enjoyed.
Absolutely. For those of you that are pursuing continuing education credits, the links are in the chat box. Make sure you open that before you leave the webinar. If it's not working for you now, bookmark it for later. Those links are active and working at the moment. Somebody wanted to just get a reminder, if you could explain again the difference between damages and relief.
Damages and relief are used oftentimes synonymously. Damages and harm is where people get mixed up. Harm is like depression. Payback for missing work because of your depression, that's damages. That's like, pay me the money because I couldn't go to work on those days because I was depressed. So harm and damages get mixed up, but damages and relief, those are oftentimes used synonymously.
Great, thank you for that clarification there. You had referenced Vostok, and somebody asked how recent Supreme Court cases have adversely affected some of these protections.
You know, so one case that I think has been helpful is the case that recognized that because of sex in the Civil Rights Act, you know, that includes sexual diversity, includes gender diversity. So I think that that's been a success for the psychological community, a rather big one. And so I would say that right now that the wins are outweighing the losses.
Okay, great. Thanks for that clarification. You mentioned some statistics near the end in terms of some of these case outcomes for people discriminated from different ethnic backgrounds. Being that we're in New Mexico with a large indigenous population here, somebody asked if you know of any statistics for Native populations.
I think it's about 0.4% in terms of composition of workforce. I believe it's under 1%. And I believe that it's similarly under 1% in terms of representation as litigants in these matters. So no clear evidence of an overrepresentation or an underrepresentation. They would fall into the same category of the House is going to win 80% of the time, given that they're not overly or underly represented.
Certainly, thank you for that. Are there any differences, complications in the legal criteria of success in right to work states?
Unsure. Yeah, I didn't come across any scholarship to that point in my research.
Gotcha, thank you. And somebody asked here at the end, how do we reconcile Williams' PTSD measure when discrimination has yet to be considered as part of the criterion in the DSM itself?
Exactly. So hence my thing about the caution, and I don't know about these measures, and I can tell you personally, I elect to not use them, but we'll see what the future holds concerning the DSM and the development of such instrumentation. I think that they're promising.
Excellent. Well, thank you so much again, Dr. Maddux, Jemour, for a very helpful presentation. Other people wanted to chime in that they found this a great presentation. Representation of St. Louis. Somebody says that is the St. Louis Arch that you referenced there at the beginning. It was good to see. That's great. Yeah. So again, a very not really talked about type of evaluation in our forensic realm. So I'm really thankful for this. Whether people have worked in more adjacent personal injury categories or otherwise, you don't know when you're going to get one of these referrals, and it's really important for us to know where to get this information, what the actual criteria are, and any pitfalls or considerations should we be contacted by anybody for workplace discrimination related issues. So thanks so much again for the work that you're doing here and all this information that you've shared with us today.
You're welcome. Thank you, Anthony. Thank you, New Mexico. Thank you, colleagues. Please stay in touch, and we'll talk soon.
Wonderful. That wraps up this week's Law and Mental Health series. Next week, we have Dr. Andrew Perkins, who will be discussing evaluating youth with problematic online sexual behavior. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time.